Hi, my name's Gerard Ross. I'm one of the medical legal advisors working for the MDU. Prior to that, I was a consultant surgeon and I still work clinically on a part-time basis. I've called this preparing for practice, the legal aspects of medical practice, but realistically, there's no way I can give you an overview of the myriad possible legal problems that a doctor might run into in their lifetime of practice. And on a nearly daily basis, doctors seem to come up with new ones. However, I thought I might be able to give you a reasonable heads up of things to look out for and a general approach that I think will serve you well. I guess if I had to give you a take-home message, it would be that you do not and should not be working in isolation. I don't mean physically. I mean, you'll have colleagues around you and you should ensure that you have a professional indemnity body, ideally the MDU obviously, in your corner because things can and most likely will go wrong. Atul Gawande said in Complications, a Surgeon's Notes on an Imperfect Science, said that we look for medicine to be an orderly field of knowledge and procedure. It is, though, an imperfect science, an enterprise of constantly changing knowledge, uncertain information, fallible individuals, and at the same time, lives on the line. There is science in what we do, but also habit, intuition, and sometimes just plain old guessing. The gap between what we know and what we aim for persists, and this gap complicates everything that we do. So what happens when things go wrong? Whilst this cartoon is slightly tongue-in-cheek, it does carry an important message that there's an expectation on us as professionals to learn from mistakes, whether they're our own or others. And when things go wrong, lots of things might eventuate. And unfortunately, a number of those things can happen at the same time. Worse for doctors is the facts might be examined and then re-examined in multiple different processes, which gives rise to this idea of a medical professional facing multiple jeopardy. So let's try and illustrate that. Imagine that a patient dies from a complication of a prescription that you write. Hopefully that'll never happen, but let's imagine that it does. The family may reasonably complain, and you might have to write a statement about your involvement. Let's imagine that you do that in a rush one evening, not really thinking about it too much. That response is then available for scrutiny by the family, and they may point out inaccuracies to the hospital. At the same time, the hospital will be convening a serious instant investigation, and your statement for that process is also given to the coroner. The trust then notices some difference between your complaint response and the SI statement and wonders whether they should be having a disciplinary investigation. The trust at the same time decides that they can't support you for the inquest as your evidence is at odds with others in the trust. Therefore, you need your own representation. It can go on and on, spiraling out of control. And they may even end up involving the GMC and sometimes even the police. Whilst this sounds unlikely, similar things happen all around the country to young and not so young doctors regularly. So let's imagine a scenario. You're working in A&E at the end of a shift. You're involved in an unsuccessful attempt to resuscitate a patient with an out-of-hospital cardiac arrest. After the shift, you tweet, "Terrible day at work. Young guy brought in by blue light in wherever you happen to work, died." A follower retweets that. The next day, you find out that the patient's family were on the way to the hospital, having been told he was seriously unwell, and found out about his death through the tweet and the retweet. I mean, this might sound unlikely, but remember, one doesn't have to mention a patient by name to reveal enough information to breach their confidentiality. People can and do put together disparate pieces of information to identify individuals. There's lots of guidance out there about this very topic. And although it may be the sort of thing that you might have brushed over in your revision and your reading before starting work, And whilst it's understandable that knowing how to interpret, I don't know, blood gases of an ill patient in the ED is more pressing, it doesn't mean this information isn't important. And not knowing it can have a serious impact. There's guidance from NHS England on social media. There's the GMC's guidance, and there will no doubt be your employer's guidance. The BBC have even picked up on the NHS England's guidance, warning staff not to tweet about their work because of the risk of putting confidential information into the public domain. As regards GMC guidance, you might know, but they have around 36 separate pieces of ethical guidance on their website at the moment. Some are short, but others are very detailed. Just because you haven't read them, the GMC will not see that as an excuse for you not following them. Similarly, as I'll come on to later, your employers will talk about subjects like information governance in your induction. Again, these topics are never as exciting as the acute areas of practice that you'll be involved in, but year on year, getting it wrong impacts negatively on doctors. Let's have a look at another scenario again. Again, this and variations on it are calls that we frequently take from young and sometimes not so young doctors. Dr. X is on a night out when visiting friends in London. He's a bit tipsy and ends up in an altercation, inverted commas, at a nightclub. The police are called, and ultimately Dr. X accepts a fixed penalty notice for £90 as a result of him being drunk and disorderly in a public place. Again, there's relevant GMC guidance about this, and omitting to let the GMC know about this sort of thing, and the list of this sort of things is quite long, can have serious impacts for a doctor. So let's look at this. Paragraph 75 of Good Medical Practice, one of their core bits of guidance. You must tell us without delay if anywhere in the world you have accepted a caution from the police or been criticised by an official inquiry, you've been charged with or found guilty of a criminal offence, or another professional body has made a finding against your registration as a result of fitness to practice procedures. Let's look at another one. You're asked to review the resuscitation status of a 19-year-old on the ward. He'd been admitted with a severe post-viral pneumonia and is deteriorating in front of your eyes. He's severe learning difficulties and can't communicate. He lives at home with an extensive care package. The registrar attends, it's 3 a.m, and everyone is in agreement it wouldn't be in the patient's best interest to be resuscitated, as any attempt would be futile. So what should you be doing here? The options, I guess, would be ringing the patient's mother to discuss resuscitation, but it's 3 a.m. Completing a DNA CPR form and asking the team on the morning to discuss it with the mother during normal working hours. I mean, it is 3 a.m. Or just completing the DNA CPR form. The mother can't force the team to resuscitate the patient where everybody agrees it would be futile. Well, again, there's guidance from this, from the GMC, and it continues to be relevant in the current pandemic. Their end-of-life care guidance has a paragraph on discussions about whether to attempt CPR. And it says that, as with other treatments, decisions about whether CPR should be attempted must be based on the circumstances and wishes of the individual patient. This might involve discussions with the patient or with those close to them, or both, as well as members of the healthcare team. Not only is there GMC guidance, but there's law relevant to this scenario. The Mental Capacity Act 2005 provides a framework for decision-making in respect of those who lack capacity, and consultation is a core part of that. And then common law. Winspear made it clear that consultation should have happened in a very similar scenario. It's not desirable to consult in the middle of the night, but the law requires that consultation with those close to the patient, where practical, takes place. So not nice at 3 a.m, but definitely practicable. Let's look at another one. Raising concerns about a colleague. A foundation doctor and a surgical attachment became concerned about one of her consultants. When she was working in his team, she was aware that he often smelt of alcohol or strong mints, and the registrars laughed that their boss was, inverted commas again, a bit of a lad. The foundation doctor was worried that if she said anything, he might make her life difficult and that her career could be harmed. So, what should the foundation doctor do? Does she need proof that the consultant's got an alcohol problem? And what's likely to happen to the consultant? So, as I hope you're seeing through this presentation, no one would want you to deal with this yourself. You would need to speak to a mentor or trusted senior colleague. And by that, I don't mean the F2 or the registrar, I really mean another consultant. You should really discuss it with your MDO too, if you're unsure of what to do. Importantly, you don't need proof before you raise concerns. And in their guidance, the GMC said, you don't need to have to wait for proof. You'll be able to justify raising a concern if you do so honestly on the basis of a reasonable belief through appropriate channels, even if you are mistaken. And remember that all doctors have a duty to raise concerns when they believe that patient safety may be at risk. The doctor actually spoke to her educational supervisor, who said that, well, no one would believe her because she didn't have any proof. And this is another important point. Doctors of all levels, senior doctors, consultants, everybody can make mistakes, and sometimes they approach things wrongly. No one is foolproof, and no one gets everything right first time. Therefore, if you're not satisfied that the responsible person has taken adequate action, then you escalate the issue within the organisation, someone more highly placed in management, for instance, and if necessary, you even contact the GMC. This is what this doctor actually ended up doing. She contacted the medical director, having discussed it with us, who took the matter more seriously. In this case, it was helpful, as the medical director dealt with the matter. The doctor later learned that there had been several serious incidents involving that consultant, and as a junior, you may not be aware of that. The GMC also investigated because it turned out that he had been abusing alcohol for some time. The consultant was suspended for practice, but after he engaged with addiction services and abstained from alcohol, he eventually returned to work under supervision. And interestingly, the educational supervisor was criticised for failing to take action. So, a doctor must act within GMC guidance. They must act within the law. They must work with their colleagues. And a doctor is often an employee of an organisation with its own policies, protocols, and procedures. The GMC guidance can be found on their website. There's core guidance, which I've referred to already a little bit, which is good medical practice. There's guidance you'd be expected to use on an almost daily basis, consent and confidentiality. And then there's guidance which you're expected to be familiar with, although you may not use it daily, such as 0 to 18 years guidance for all doctors and raising that to concerns about patient safety. The point is, though, that there's a huge amount of it out there. And this is the stuff that is mandatory to know about from the GMC's point of view. The GMC is a statutory regulator. That means the GMC is authorised by law to set out guidance and also to investigate and sanction doctors for serious or repeated breaches of the guidance. In their guidance, they say doctors must be honest and trustworthy, act with integrity and within the law. They must use your judgment in applying the principles to the various situations which you'll face as a doctor. You must be prepared to explain and justify your decisions. So the guidance is clear that it requires you to use your judgment. It's not always black and white, and it is purposefully phrased broadly because it's intended to cover a potentially broad range of circumstances. So, as I mentioned at the start of this talk, how do we think you should deal with this difficult problem of multiple jeopardy? The first point, I think, is to make the care of patients your first concern. Next one would be Be open and honest, and never alter notes after the fact. You have to have an awareness of potentially serious issues and seek advice early. You can't know everything about all the issues you will face. But I think as young doctors, you have an advantage. The skills of reflection and analysis which you've been encouraged to develop during medical school will help you to respond appropriately should things go wrong in your clinical career. And that approach to learning in medical schools is no accident. The GMC look to assessing issues in a similar way. They are really interested in seeing that doctors demonstrate insight and remediation. For instance, demonstrating that you've thought about something, you've learned from it, you've tried to put it right, and you've shared your learning to avoid others having the same issues. That approach to something going wrong, that demonstration of your savviness, is something that will be helpful if things do go wrong for you. So let's quickly come down to some general tips. The first would be approach the legal problems that you come across as you would any other aspect of practice. Work within the limits of your competence. Look for guidance about what to do. Look at your employer's or local policies and seek advice from senior colleagues as well as your defence organisation. What I'm really trying to get across through these scenarios are some nuggets of information which you might find helpful, was that medical legal aspects of your practice are no different from any other areas of your medical practice. Increasingly though, the issues which lie behind legal problems are complex and are not simply based on sound common sense. You'll become very familiar with some aspects of this quickly, but when you do come across a situation that you've not met before, stop and think. Do you know enough to proceed? Do you need to take some advice? That's what your MDO and your senior colleagues are there for. Another thing to think about is your induction. You might think you've got a lot more to learn or worry about than the topics which come up in induction, some of which I've listed here. So information governance, mental capacity, safeguarding and child protection, DNA CPR, duty of candour, fire safety. And if you're lucky, you might not have to deal with a complex scenario in any of these areas at all, although you will come across them, I'm sure. Having to deal with them, however, becomes more likely the more senior you become. You're, after all, the consultants and the GP specialists of tomorrow. The topics that trusts talk about in induction are chosen carefully and usually relate to areas where there's a fairly clear set of legal obligations on you or your employer to operate in a particular way. So I'm thinking of things like the Mental Capacity Act or the Data Protection Act when I say that. Essentially, in their policies, your employer or trust should have digested the sometimes complex legal requirements and distilled them into a more straightforward policy that implements them effectively and allows you to understand what you need to do in any one situation. You might not remember it all, but try and remember where to look and who to contact if you're faced with one of these scenarios. Employers and regulators do not expect every single clinical incident to go perfectly and by the book, and I guarantee you that they won't. Mistakes will happen, and they will happen to you. However, handled properly, it's unlikely that a single clinical incident will result in the end of anyone's clinical career. It's always impossible to judge how far a matter will escalate, however, and they can rumble on for a long time. So you want to make sure that any report you write is as good as it can be when it goes in. So if you're asked to provide a report in respect of a clinical incident, make sure it's clear, make sure it's accurate, so look at the notes, and make sure it's written in plain English so that the management, for instance, or the coroner or a lawyer can understand what you're trying to say. Try not to use lots of medical terminology without explanation. When you submit the report, make sure the person dealing with the matter has your contact details and ask that they keep you updated. we do note sometimes with young doctors moving around through different jobs that trusts lose contact with them, and then doctors find out that things have escalated unexpectedly, and they haven't been aware of this escalation. So coming back to brass tacks, if you're asked to write a report about something, then make sure your report is accurate and get someone to look over it with you. We do that for our members all the time. Avoid trouble when you can. This is quite a difficult one. I've broken it down into three areas. The first to say is social media. Social media has lots of benefits, and you'll know more about that than me. But there is an issue that social media can result in problems, particularly for young doctors. It can break down boundaries, it can result in unexpected breaches of confidentiality, and it can result in comments you make in a private group, for instance, being spread more widely than you might wish. We have certainly seen complaints arising in this context. And the GMC also have quite a lot to say about it. They've got their own guidance on social media. One thing they make clear, though, is that if you say something in a publicly accessible social media outlet and you identify yourself as a doctor, you should identify yourself by name. Any material written by authors who represent themselves as doctors is likely to be taken on trust and may reasonably, in their view, be taken to represent the views of the profession more widely. So you should also be aware that content uploaded anonymously can, in many cases, be traced back to its point of origin. So just bear that in mind when you're making comments in what you think is a closed group. Take care with CVs and application forms. We often see cases where concerns have been raised about a doctor's probity because of material on an application form or CV. More often than not, it's because the information is outdated and you've just failed to remove courses or qualifications that you plan to do that were never undertaken. But if these are repeated mistakes, then people can imagine this is down to you being less than fully honest. And I've already mentioned the issues around criminal and regulatory proceedings when you have to report yourself to the GMC. Bear in mind that although you're a doctor, you're someone who may be yourself in need of medical help at some points in your life as well. So register with a GP. Don't prescribe for yourself or for your colleagues if asked to do so. And if you think you have a health problem relevant to your practice, take independent advice and follow it. So that might be from occupational health or your GP. So why do you need professional indemnity? Well, it's a GMC requirement that all registered doctors must be able to show they have adequate and appropriate insurance or indemnity in place. And as a doctor working in the NHS, your employer is actually liable for any negligent acts arising from your NHS practice under the NHS indemnity provided to NHS bodies. So that indemnity will cover financial consequences of claims for clinical negligence. However, it doesn't protect you and your professional interests. If you encounter other problems not covered by the NHS scheme, for instance, a GMC investigation or a disciplinary investigation related to your clinical practice, or even a coroner's investigation where you and the trust have parted ways, which sometimes happens, it's likely to leave you exposed and without support, and that can be exceptionally expensive. NDU membership can provide indemnity to fill the gaps left to you from indemnity provided by NHS bodies. And we firmly believe it's in your best interest to have access to your own professional medical legal advice and support. Over 200,000 of your fellow doctors, dentists, and allied health professionals agree with me. Remember to sign up for F1 membership. Your student membership ends on the first day of the month following your qualification as a doctor, and it's important that you're indemnified from the minute you start work. F1 membership is only £10 and provide access to professional indemnity for clinical negligence claims, expert advice, support with practical matters such as how to handle a complaint or write a report, and support for your professional development. If you complete a foundation doctor application form today, you also receive a gift. I hope that's given you some ideas about how you might address some of the issues you may face at some point in the future. I wish you the very best and look forward to welcoming you into membership of the MDU.